Good afternoon. My name is Alan Albright.
I'm Nash Zogabe.
And we're here to give you our spin on what we think the outcome will be, or the outlook will be, for the recent Octane Fitness case from the Supreme Court.
So recently, the U.S. Supreme Court, in a unanimous decision, changed the rules on how attorney's fees are awarded in cases of unreasonable litigation lawsuits. Traditionally, the test was a strict test where clear and convincing evidence standard was used to prove that the plaintiff's claims were objectively baseless and brought in bad faith. However, with this decision, the rules have relaxed to a preponderance of evidence standard, where the judges are afforded more latitude in awarding attorney's fees in these cases. Now, the general sentiment is that the group that is affected the most with this decision are the non-practicing entities, such as patent trolls, because it would deter them from filing baseless lawsuits or somewhat frivolous lawsuits against big companies to induce settlements, licensing, or other arrangements. However, as Alan will explain, this is a part of the story.
Sure. We definitely think that this opinion is going to have an effect on at least one end of the spectrum. We think that there are non-practicing entities whose practice has been to sue a substantial number of potential defendants or real defendants, and they simply are trying to get as much money as they can that's less than any possible cost of defense. And we think that this decision is going to have a significant impact in deterring those cases. But there are certainly very substantial players like Intellectual Ventures or Alcatel-Lucent, who either have invested substantially in IP or have grown their own IP, who are out with very effective licensing campaigns, and we don't see that this case is going to have very much of an effect on them at all. In other words, we don't think that this was necessarily a death knell the way it was described in public. In fact, if you look just last week, there were over 100 cases, in fact close to 200 cases, that were filed in one day in the Eastern District of Texas. And that was largely motivated by the potential that Congress is going to pass the Innovation Act. It really had nothing to do with the Supreme Court's decision. Nash?
Well, one of the major impact that we're going to see is that either party can lose. So, for example, a smart plaintiff may pick a jurisdiction that is unlikely to award fees under Section 285 of the patent law against plaintiffs. Another part is that the Section 285 could be used against by plaintiffs against defendants under the slower standard. But there's even more impact, as Alan will explain.
Yeah, I think that's actually something that wasn't reported on at all, which is that now either party can seek attorney's fees under a lowered standard. So in our opinion, the progress that some companies or defendants had made by the difficulty in obtaining an injunction or a finding of willfulness may have been done or undone just a little bit by this decision, because now plaintiffs can seek attorney's fees under the lower standard, and of course the defendants, if they're successful, can as well. The bottom line is we think that this has ramifications for all of the parties to patent litigation, and it's much less one-sided than was reported in the press. Thank you so much for joining us today, and if you want more information, please go to our website, www.sutherland.com. Thank you.